Welcome to the Deep Dive, where we take a stack of sources, articles, research history, and try to distill it all into the essential knowledge you need. Today, we are diving deep into tort law, a topic that really, it regulates how we handle almost all accidental harm in modern life. And I think the place to start is right there with the name, the word tort. It comes from the Latin tortum, which means crooked or wrong. And that kind of tells you everything, because this system is fundamentally about dealing with private civil wrongs. It allows the injured party you to seek a legal remedy.
It's the ultimate body of rules on responsibility for injury, and its scope is just astounding. We aren't just talking about a broken arm. Tort law protects interests from your physical body and your psychiatric health all the way through to your reputation, your property rights, even complex economic interests.
And when we say remedies, we're usually talking about money, right? Financial damages. Trying to make the injured person whole again.
Mostly, yes, but it can also involve something like an injunction, which forces the party to, stop doing the harmful thing. To really understand the landscape, you need to know there's a kind of spectrum of liability. On one end, you've got strict liability.
And that's imposed regardless of any fault.
Exactly. No fault needed. Think of a manufacturer who puts a defective product on the market. If that product injures someone, they're responsible, even if they followed every single safety protocol. They don't have to be morally to blame.
But most cases, and what we'll really focus on today, is fault liability.
Mm-hmm.
That's the standard for negligence, and it requires us to measure the defendant's conduct against a very specific metric.
That's the conduct of the hypothetical reasonable person. We asked, completely objectively, did the defendant fail to take the care that a reasonable, prudent person would have taken in those circumstances?
So it doesn't matter if they were having a bad day or their reflexes are slow.
Nope. The law judges the action, not the person's individual limitations.
Okay, so our mission for this deep dive is to understand how this very subjective, often reactive system, rooted in these ancient crooked wrongs, became the central way modern society handles accidental harm. And especially how that reasonable person standard came to dominate everything.
Let's unpack the history, because the system we have today wasn't really designed. It was sort of forced into existence.
That is the key takeaway. If you go back, say, to Blackstone's time, the law was focused almost entirely on intentional torts.
So you hit someone, you committed a wrong. Simple.
Right. And the legal system was there to act on that Aristotelian idea that the judge is just a disinterested referee there to correct the injustice between two people, restore the moral balance. It was a private fight, settled in public.
It almost sounds like a lawful avenue for bloodless revenge.
That's a great way to put it. Settling a private score. But then the world changed.
Dramatically.
It did, the Industrial Revolution. Suddenly you have factories, railroads, mass urbanization, and critically, this explosion of complex accidental injuries between people who didn't know each other from Adam. Strangers.
Exactly. And the old system, based on intentional wrongs, was just wholly incapable of handling this new scale of accidental harm. It became a huge societal concern.
And this is where the thinking shifts, right? From the morality of a single act to the economics of the entire system.
Precisely. This is the shift you see with jurists like Guido Calabresi. He wasn't just focused on individual wrongdoing, but on dealing with what he called the costs of accidents. Injury wasn't just a moral failing anymore. It was an economic burden on all of society.
So the question becomes, who can best absorb that cost or prevent it?
Exactly. And that radically shifted tort law's purpose away from just adjudicating private wrongs and towards a much bigger focus on deterrence and compensation, but on a societal scale.
Which means tort law stopped being about private scores and started to look a lot more like a tool for public regulation.
That's it. Legal thinkers at the time, people like Oliver Wendell Holmes Jr., part of the legal realism movement, argued that the law had to adapt. It had to apply collective solutions to these huge personal injury problems. And this is why so many scholars today see tort law as a vessel for public good regulation. It's almost become, in effect, public law.
But that reactive sort of piecemeal development created a pretty messy structure, and now there's this academic tension. Are we dealing with the law of tort, as in one single unified principle?
Or the law of torts plural, just a chaotic jumble of different separate claims?
And that tension is what fuels the critics.
It absolutely does. They argue that if the rules just developed in this haphazard way, are the goals of compensation and deterrence really being met, or is it all just a really inefficient system? And that's why you see alternatives constantly being proposed, like the no-fault state-sponsored compensation funds they have in New Zealand.
Where they just focus on pure, efficient compensation, not on finding who is at fault.
Right. They've taken fault out of the equation for most accidental injuries.
That historical pivot really sets the stage. So let's look at what the system claims to do today, starting with its two main functions.
Okay, the first one is the most obvious. Compensation. The goal is to put the injured party back, financially, into the position they were in before the injury.
But that's a promise that can't always be kept, can it?
No, it's often an impossible promise. I mean, if a terrible accident leaves someone paralyzed, money can provide amazing care, but it can never, ever restore what was actually lost. It's solace. It's not true restoration.
And the second function is vindication, which is a bit subtler.
It is, but it's just as vital. It's about sending a signal to society. When a court finds someone liable, it vindicates the plaintiff's right to be respected. It shows their interests were infringed upon.
And this matters even when there is no physical harm.
Especially then. Think about the tort of assault. The harm is the threat itself. The court is saying your right not to be threatened was violated, and that matters.
Okay, so now we get to the big philosophical fight. Corrective justice versus distributive justice. Let's start with the classic corrective view.
Corrective justice is purely individualistic. It's Aristotle's view, really.
Yeah.
A driver negligently breaks a pedestrian's legs, he is taken away from the pedestrian. So tort law lets the pedestrian take back through damages.
It's transactional, restores the balance just between those two parties.
Exactly. It's a closed loop.
But distributive justice forces us to zoom out, to look at the bigger picture.
It does. It asks, what are the wider societal consequences of imposing liability here? Take the classic example of a drunk customer suing the publican who negligently overserved him.
Okay.
Now, corrective justice might say, yeah, a wrong occurred between those two, but judges often reject liability in these cases.
Why is that?
Because of distributive justice. They think imposing that liability would put huge onerous burdens on all publicans. Insurance costs would skyrocket, which society ultimately pays for, and critically, it undermines the whole idea of self-responsibility.
That an adult is responsible for their own choices.
Right, so the courts decide that for the system as a whole, it would be unjust, even if it feels right just between those two people.
That really shows that transition we were talking about. Tort law as social policy, not just private morality.
And finally, there's the subsidiary function, deterrence. The theory, and this is big in economic analysis of law, is that people and companies are rational actors. They'll avoid risky behavior if they know they'll have to pay for the consequences.
But how effective is that deterrence in the real world? For a big company, isn't liability just a cost of doing business, managed through insurance?
That's a huge criticism. Insurance can neutralize the financial sting for the actual person who made the bad decision, which weakens the deterrent effect. And remember, this system only intervenes after the wrong has happened. It's not really preventative.
And let's be honest, most of us are deterred by the general idea of getting sued, not by knowing the specific legal rules.
Exactly. So its value as a deterrent is, let's say, highly questionable in many contexts.
Okay, to really get a grip on tort law, we have to see how it fits with its legal neighbors. Let's start with contract law. They're both civil, right? Private parties, private remedies. The standard of proof is the lower one, the balance of probabilities.
Right. But they regulate fundamentally different things. Contract is about obligations that are decided in advance and are voluntarily assumed. You agree to the terms.
You opt in.
You opt in. Tort, on the other hand, deals with involuntary obligations imposed by law after something happens. You never volunteered not to injure a stranger on the street, but the law imposes that duty on you.
And the goal of the compensation is different, too.
Very different. In contract, you compensate for defeated expectations, what the plaintiff would have earned. In tort, you're trying to restore the position they were in before the tort happened.
Okay, what about the contrast with criminal law? That seems much sharper.
Oh, much sharper. Criminal law is about a public purpose. It's prosecuted by the state.
The DPP, for instance.
Right. And it aims for punishment, maybe prison time, and requires proof beyond a reasonable doubt.
Whereas tort is private purpose, Private parties aiming for compensation, and you only need to meet the balance of probabilities.
Exactly, a much lower bar.
And that separation gives us some really compelling legal drama. We see these huge cases, like the Omaha bombing civil suits or the O.J. Simpson trial, where someone was acquitted criminally.
But is then found liable in a civil tort case. The two systems serve totally different masters, so it's not double jeopardy.
Okay, and one last neighbor, constitutional rights. How do they intersect?
Well, tort claims are generally what we call horizontal liability private person versus private person. And our sources are clear that tort law is seen as the primary way to vindicate constitutional rights in those civil matters. You'd only make a direct constitutional claim if the existing torts were, and the term used is basically ineffective.
And we see this play out all the time in privacy cases.
All the time. And in those cases, the context of what the plaintiff did is often everything. Take the two rulings we looked at. In one, a woman sued because transcripts of illegally obtained phone calls about an affair were published. The court balanced her privacy against free speech and said, you know what? Publishing the actual transcripts was disproportionate. Her right was upheld.
But in the other case, context changed the outcome completely.
It did. A woman had a photograph taken of her leaving the registry of births. Her claim failed.
Why?
Because she had already publicized her relationship extensively, and the photo was taken in a public place. The court basically said she had no legitimate expectation of privacy in that specific situation. So the law adapts based on how you present yourself to the world.
And that idea of context brings us perfectly to the engine room of all this, the modern tort of negligence, and its most important element, the duty of care. Negligence regulates almost everything we do, driving, medicine, you name it. And it was really born in 1932 with the landmark case, Donahue v. Stevenson.
Ah, the snail in the bottle. It's a case you can't forget because of that one detail. The plaintiff is drinking a ginger beer with ice cream, and when the dark, opaque bottle is almost empty, she discovers the decomposed remains of a snail.
Ugh, yeah, just thinking about it is horrible.
It was a repulsive discovery, but legally it was absolutely revolutionary. Before this, to sue the manufacturer, she would have needed what's called privity of contract.
Meaning she had to have bought the drink herself.
Yes, but her friend had bought it for her, so under the old law, her claim was doomed.
But the court made this radical break and created a generalized tort of negligence. And it was Lord Atkin who gave us the framework for it, the famous Neighbour principle.
That's the one. It was drawn from morality, but designed to be a broad legal principle. Lord Atkin said, the rule that you are to love your neighbor becomes, in law, you must not injure your neighbor. And then he gave the key legal definition of who your neighbor is. Persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation.
So for you listening, if you're injured and you want to sue in negligence today, you need to prove 4 essential things that come right from that principle.
That's right. You have to prove, 1, a duty of care was owed to you. 2, there was a failure to conform to that standard. That's the fault.
Okay.
3, you suffered actual loss or damage. And 4, there was a close enough causal connection between the defendant's fault and your injury.
And of those 4, that first one, the duty of care, is the big one. It acts as a kind of judicial gatekeeper.
It is absolutely a tool of social policy that judges use. The court uses the duty element to look beyond just the 2 people in the case and consider the wider societal impact. They ask, is it a good idea to impose this duty here?
So they use it to stop the floodgates opening on claims, or to protect valuable activities from being crushed by liability.
Precisely.
And finally, let's just circle back to the core of fault liability, that objective standard of conduct. I think it was in Blythe v. Birmingham Waterworks, where fault was defined as the omission to do something which a reasonable man would do.
A standard that is purely objective. It sets the bar really high, sometimes called a gold standard. It measures your actions against this hypothetical reasonable person, and it's applied regardless of your own personal characteristics or what you could subjectively do.
So if you act with less skill than this imaginary person, you're negligent. Full stop.
Full stop.
So we've covered a huge amount of ground here. Tort law began as this collection of private, crooked wrongs and was then forced by the industrial age to become this huge mechanism for public regulation and compensation. And it's all built around the central objective measuring stick, the reasonable person.
And yet, for all that evolution, the system is still deeply flawed. Because it's fault-based, it only compensates a tiny fraction of accident victims. It's slow, it's adversarial, it's inefficient, which is why that debate over replacing it with no-fault alternatives is never going to go away.
And that leads us to the final provocative thought we want to leave you with, and it connects right back to that objective standard. Since the standard of care in negligence is that of the hypothetical reasonable man, you are liable for failing to meet it, even if you genuinely believe, because of your own limitations, you couldn't have acted any differently. In a system so obsessed with individual fault, how just is it, really, to be judged not by your own capabilities, but by the abilities of a theoretical, flawless stranger, something to mull over until our next deep dive.